Good morning or afternoon, depending on which it is for you. My name is Dr. Tim Cote, and this is our first lecture in the course U.S. Fundamentals of U.S. FDA Regulatory Law. And here, indeed, is the book of this course, A Practical Guide to Food and Drug Law Regulation, 3rd edition, which is published by the FELDI, the Food and Drug Law Institute. My name, again, is Dr. Tim Cote, and I'm one of the professors here at the Keck Graduate Institute in Claremont, California. This will be a 16-part course, and I will try to jazz it up with some introductory PowerPoints and so on as we move forward. But at this point, there will be a series of 45-minute lectures, and 16 45-minute lectures followed by 45 minutes of classroom discussion to include discussion of certain FDA regulatory guidances. So we should have a good time here, hopefully. This will be part of distance, part in class here in Claremont, California. As many of you know, I also am the Chief Medical Officer for the National Organization for Rare Disorders out there in Claremont, California. And it keeps me on the East Coast 3 weeks out of every 4, and out here in Claremont 1 week. So let's dive right into it. Now this sounds like a boring topic, doesn't it? Regulation, studying regulation. But in actuality, why do we have drug regulation? We've had drug regulation since time immemorial. If you take the broader view of it, there's always been some human being, at least one, who has juxtaposed him or herself between this active substance called a drug and a human being that might receive it for the treatment of a disease or enhancement or whatever. There's been some regulation for numbers of different reasons. For one, a lot of drugs are addictive. Okay, they can destroy lives as well as heal lives and cure lives. Number two, somebody needs to know what the right drug is to be given to a person for their particular needs. So there is a body of knowledge that not all human beings can possess. So some specialized ones do, and you're all going to be part of that. And then, of course, there's always the political trappings as society has become increasingly complex. Some people want to have the power. And regulation is about the power to control that interaction between a substance and a human being. So we're going to talk for the next 16 lectures about how that is done in our society as Americans here at the Food and Drug Administration. Is where the focus will be. Hopefully there'll be another series of lectures like this on the EMA process, the European Medicines Agency. Here in the U.S., drug regulation is deeply steeped in the democratic process, in who Americans are. And because a large portion of the KGI community are international students, this is the lecture in which you're going to get a lot of orientation to the American political system, the origins of our democracy, and how our government works. For those of you who are native-born Americans, a lot of this will be repetition from what you heard in high school and junior high school and civics class, or what we call social studies. But you need to understand this in order to be able to understand the FDA, where it comes from, and what it's all about. So let's get started. The United States was started in 1776, and this thing called the Constitution, the document upon which, first of all, I know that this is going to be a little funny, having a doctor profess law to you, but this is how this business of drug regulation sits at the interface of medicine and the sciences and the legal profession and lawyering. So unfortunately, you're getting this from an MD. Maybe you'll get it from a legal expert later on, but you can see that this is a gamish, a smearing of those two disciplines, and I hope you find that interesting. I do, even though I'm not a lawyer. So America was founded on the basis of a document called the U.S. Constitution. It set out how our government was framed. It specifically stated that there were 3 branches of government. Now, if you were here, I would ask the Americans to say they're legislative, the executive, and the judiciary. Each of these has certain powers invested in it, and there are a series of checks and balances to make sure that no one of them retain all the powers. This was thought to be important to the original colonists in the 1700s because they were looking back across the Atlantic at the king in England and decided that they specifically didn't want that. They wanted something different. It is the oldest democracy, the oldest constitution. As a person who served in uniform for 23 years, I'm extremely proud of our nation's history, but you need to know that this is not a digression, but rather intimately connected to how the FDA works. So, the other thing that the Constitution does, besides set up the structure of the U.S. government, is it defines the powers and the separation of powers between what is central, what is a federal power, and which powers reside with the states. This is important also because any powers which are not specifically allocated to the federal government are by default allocated to state regulators. So, for example, the Food and Drug Administration regulates the interstate commerce of drugs. Now, broadly interpreted, it's pretty hard to have commerce for a specific drug which is limited to just one state, because API, or the large bulk active ingredient, usually comes from someplace else. The packaging might come from someplace else. Certainly you're going to want sales that go beyond a certain one of the 50 states. So, but in theory, at any rate, completely intra-state commerce is not regulated by the FDA of drugs. So, what are the central powers of that were allocated that are relevant to the FDA? The power to import and to export from other countries is exclusively vested within the FDA. The policing state is invested with the FDA. Intrastate commerce, as I mentioned already, is invested with the FDA, and this is incredibly important. You should know that most public health activity, and the Food and Drug Administration is a public health agency, is actually invested in the states. So it is the state health department that collects information on who has gonorrhea, what's the most recent outbreak of any number of reportable diseases, and how to actuate those public health activities. Really, most of the capacity resides in the states. This has been a long, for those of you who are not Native Americans, it is a long resonating theme in our country's history, is this tension between state powers, which are distributed out to the 50 states, and the central powers of the federal government. There has been a shift over these 200 years of Americana to an increasingly powerful central government, and yet states' rights have remained how most things get done in life, actually, in America. And incredibly important. This was the crux of our own Civil War. The issue of slavery was framed in the context of that struggle between who has the right to decide that issue. Is it a state-based issue, or is it a federal issue where the central government can decide? So this is important for drug regulation because the Food and Drug Administration, as you all know, is in fact a federal agency and depends upon those powers which it receives from the Constitution in order to function. There is a concept, all of this information, by the way, is included in this book. This is a brief review of it. The classroom discussions can clear up additional areas that you may not know. There's a notion of federal preemption, which is to say when there are two laws, one federal law which addresses an issue and a state law which addresses an issue, the federal law preempts the state law and is the overriding power with regards to what the truth is. So, for example, there were court cases about states would sometimes enact special laws on vaccine-related injuries, and court cases have decided that no, it is the federal laws on how compensation shall occur for persons who are injured through adverse events that occur with vaccines, not the state laws, and it is not valid to enforce the state laws because the federal law preempts the state laws there. Likewise, tobacco labeling is defined by the federal law, and states are not permitted to enact other laws that say, no, no, you need to label tobacco and tobacco-related products this way or that way. Okay, so let's talk about these three branches of government. The first is the legislature. Legislature are the people's elected representatives. There are two bodies to this. They are called the House of Representatives and the Senate. The House of Representatives are elected for a fairly short period of time, and the Senate members are elected for a long period of time. They influence agencies like the Food and Drug Agency through at least three functions. The first being enabling legislation. That's legislation that sets forth what the scope of that agency's powers are. It says, here's what you can do, here's what you are enabled to do on our behalf. And without the passage of a bill that enables that to occur, there isn't going to be an agency which can exercise that authority, because the authority comes from the people itself. This is the notion of democracy, that the people elect representatives and that the people govern themselves. That's the whole notion. And secondly, budget. The legislature, specifically the House of Representatives, controls the budgetary process, decides, okay, the people who have to pay for the budget through their taxes are going to allocate this much money to the Food and Drug Administration. And finally, there is oversight. So the Senate and the House have oversight powers to allow them to see how that executive branch, which we're going to get to in just a moment, functions in its action with regards to doing the will of the people through the enabling legislation and the budget, which is resources which have been allocated to it. Okay, that was legislative branch. Branch number two, executive branch. These are the people who get the things done in the government. The Food and Drug Administration is, in fact, a part of the executive branch. It enforces and implements the legislative bills, which become statute or law, including the Food and Drug and Cosmetic Act, about which we will talk a great deal in our next lecture. The commissioner herself at this time is appointed by the President of the United States, also an elected person. However, that agency is only able to enact rules or law, regulations they are called, on the basis of a statute which enables the creation of such regulation. We'll talk a little bit more about that shortly in this lecture. And finally, we have the judiciary. Those are the courts, and their role is, in this third part of government, is to interpret the will of Congress, the legislative branch, and whether or not it jives with whether it is constitutional. Is it correct in the context of the Constitution? If it is not found to be appropriate with regards to the Constitution and its amendments, one of the most important ones being the first 10 amendments, which are called the Bill of Rights, then it can be found, a law can be struck down. It can be found to be unconstitutional and can no longer be enforced. So the courts have an important role to play in determining what is going to happen in drug regulation, as in much of the rest of this wonderful place we call America. So that is your little trip through American government. 10 sessions of social studies boiled down into just a few minutes. Let's talk a little bit about the system of checks and balances. So, what are checks and balances? The president has a check on the legislature because the president has the power of the veto. Now, the president can't stop any law from occurring if the legislature wants a law to occur. If they pass a law, pass a bill, and a bill is a possible law. They pass the bill, they send it on to the president. The president can sign it or he can veto it. If he signs it, it becomes law. If he vetoes it, then it goes back to the legislature, and they then must raise a 2/3 majority in order for that law to go on and that bill to go on and become a law. That's one check on the power of the legislature that the president has. The president has special powers that are awarded exclusively to the president, including the, well, as I've said already, the Food and Drug Administration is directly underneath the president. So he is responsible for effecting the will of the Congress. And he has other special privileges, such as being commander-in-chief, that are exclusively allocated to the president. The president has a check on the Supreme Court in that the Supreme Court members are appointed by the president, and it's only the president who can appoint a Supreme Court member who serves for life. And so the presidency can have an effect there. The Supreme Court has checks and balances upon both the president and the legislature because they can declare that laws are unconstitutional, that they're not fitting with the Constitution. So there is this balance of powers. The framers of the Constitution, the people who developed American government, decided that we don't want it all to go to one king. We don't want it all to go to one place. We're going to distribute the power and allow government to proceed fairly slowly, but it to try to most accurately reflect the will of the people, this notion we call democracy. Okay? And I know this is a little pedantic, and I know it sounds far from drug development and drug regulation, but it is the backdrop against which drug regulation occurs. So, we're going to talk a little bit about the court system because a lot of drug regulations occur through courts. What happens if there is a seizure and it's contested? What happens if there are adverse events and people get sick and they die and they want compensation? What happens if people want to sue a drug company for any number of reasons? Those go through a court. So the U.S. court system is founded upon this common law system. There are any numbers of different ways that different countries can found their court system, but it's founded upon common law. What that means is that judges depend upon what other judges thought of their opinions in order to develop new opinions. So there's this concept of precedence of common law. It has some advantages because each one of these decisions is very particular to a particular case. It's very adaptable. So as technology changes and new things happen, new case law can emerge that is dependent upon the particulars of a new day. And things are very different from how they were in 1776 now. Now the disadvantage is that it takes a long time to flesh out what things are like right now. So to get case law, because court cases tend to proceed very, very slowly, it can take a while before you know what the rules really are. Also, the U.S. court system is an adversarial system. So it is a system which is driven by the actions of litigants, not the actions of judges. So if you're following me, this means that judges don't decide this is on their own and without a motivating principle of a conflict of two adversaries coming together. Judges don't decide whether a law is constitutional or not. It's dependent upon the particulars of a particular case. Now, the advantages of that are that citizens who are jurors who sit and decide upon how laws should be interpreted and whether they're constitutional or not are actually, it's the citizen jurors who are vested with the power to influence government. The disadvantage is that it can't deal with complicated legal and scientific issues. In product liability cases, for example, jurors tend, or frequently, will interpret a case based upon matters which are not, which they don't have a complete, thorough understanding of the scientific background. It's very hard to give a panel of 12 jurors a degree in biology over the course of the time it takes to run a trial. So these complicated issues can't be as fully dealt with under an adversarial system as they might be by particular specialists. So there are advantages and disadvantages. Now, our court system is divided into two main categories. There is criminal law and civil law. Both are affected in drug development cases. Criminal law is, you could broadly define it as laws which, if broken, might end up in a person being imprisoned. Okay, so you can only be imprisoned under criminal law, or death, for that matter. In many states, there is a death penalty in the United States. Criminals, or people who are charged with criminal offenses, are entitled to certain rights in this country. They can have free legal counsel if they don't have the means to represent themselves. They are entitled to a trial by jury, not a trial by a judge. They are entitled to not be forced to testify against themselves, called pleading the fifth. They may refuse to speak to the police and to self-incriminate themselves in that way. They are free from unreasonable search or seizure. And I said unreasonable, meaning that there is no reason. They are free from that. Now, if there is a reason, there can be search and seizure, but they are free from unreasonable, wanton, blank check anytime that they want, search and seizure. And finally, the government must, in a criminal case, the government must prove its case beyond a reasonable doubt. That is a very high bar. Okay, so and you'll hear a different story from civil cases. So beyond a reasonable doubt. And finally, lastly, in a criminal case, the accused stands innocent until proven guilty. And proven guilty means that a jury of their peers has unanimously, usually, decided that they are in fact guilty. So, criminal court system in the United States affords the accused a high level of protections that are built into the system. And there are many criminal cases as well in food and drug law regulation, fraud, and there are other criminal charges that can have worked their way through the system in U.S. food and drug law regulation. Civil cases, in contrast, are usually for losses of property or persons. Losses to the person, injuries, or property, such as, so for example, malpractice law is in fact a civil proceeding. The bar here is no longer beyond a reasonable doubt, but is the preponderance of evidence. Preponderance is like 51%. If in sum, the weight of the evidence is one direction or another, not beyond a reasonable doubt. And I hope you can see the distinction between the two. Civil suits can be brought by individuals or by governments, whereas criminal cases are brought by government generally. And the victims are not the plaintiffs. The victims are the people who stand as witnesses for the government. The government is accusing the person accused of conducting a criminal act. But in civil claims, this is not the case. Civil claims are regulated through the Uniform Commercial Code. It's been adopted by all states, and it's the proceedings on which civil cases move through the system. It includes the ability to compensate for personal injuries, so tort lawsuits. And for example, in the food and drug law, take for example the, So what I want to tell you is a couple of different means by which civil litigants can make their case against in the context of food and drug law. So compensation for personal injury can occur in a couple of different ways. There is the negligence concept and the strict liability concept. So to make a claim on the basis of negligence in a civil suit, you must show what a reasonable person would do. So let's take for an example the case as is shown in the text of a laboratory test for cancer. And I believe that the example that they alluded to there was the Papa-Nicolau test. What happens when the Papa-Nicolau test is missed? If you were to make a case that this particular laboratory was negligent in a Papa-Nicolau test, and therefore this whole collection of patients suffered because they did not have their cancer detected early enough and went on to have some serious medical consequences as a failure of that test because you're claiming that it was negligent, you would have to prove what a reasonable laboratory would do, a reasonable laboratory, and how this deficient laboratory is somehow different and falling short, and how that resulted in claiming harm. That's how one would make a case for negligence. So a product or a laboratory regulated under Food and Drug Law can proceed on the basis of negligence, or there's the concept of strict liability. And all states have a strict liability clause. There, in contrast to negligence, you must prove that the product itself was defective, unreasonably dangerous, and the cause of the injury. So, for example, if you have a new drug and it doesn't show any adverse events in clinical trials, but subsequently in post-marketing survey you have post-marketing data that comes in, and we'll talk about that later in this series, you discover that there's a large number of cases of hepatic failure that couldn't have been detected in clinical trials because the clinical trials maybe had 300, 500 people in them, and this occurred 1 out of every 2,000 people who received the drug had sudden hepatic failure and died. Then you could be liable under the strict liability clause for your particular drug. So I hope that's useful. Court cases, the most time and expense of court cases is a process called discovery. Discovery is the process through which information is learned and prepared, requested, and there are 3 ways that discovery three main tools for the collection of new evidence for discovery. Depositions, that's in person or a video, interviews in which people relate facts of the matter of a case. Interrogatories, which are similar except that they are written responses to written questions which are prepared in advance and affirmed as being from the person that you're asking. Or subpoenas, which are court-generated requests for specific records or specific pieces of information. A lot of the law in Food and Drug Law, and again, you are having a physician deliver to you this legal lecture, and I can assure you that many that will follow this lecture are more concretely tied to the development of particular drugs. But this is the backdrop in which you need to understand. Much of the law that proceeds does not occur in the courts, and instead occurs in the context of administrative law by administrative judges, who are based within the agencies, based within Health and Human Services or within the Food and Drug Agency. The Department of Justice is the only part of the federal government which can take criminal case and prosecute criminal cases from the Food and Drug Administration, I think from all of Health and Human Services. So the Department of Justice is the arm that actually prosecutes criminal charges. You should know that in the course of most cases, and this is a issue that I will return to shortly, courts generally defer to the agency's decisions if the agency hasn't exceeded its authority. Its authority being defined, as I mentioned earlier, by its implementing legislation, the enabling legislation, the legislation which defines what the scope of that agency's powers are. So let's take the case that occurred, I believe it was in 1908, cited in the book, of the frozen chicken case, okay? So there were these frozen chickens, they thawed out because the refrigeration didn't work. They got the refrigeration working again. The manufacturer wanted to sell the chickens, and the health authorities said, no, we're going to confiscate them all, and we're going to confiscate them now, and we're not going to let you sell them, and we're going to destroy them. And they did that. Then the owner of the frozen chickens, now the destroyed chickens, goes back and says, no, I want you to pay me for these things because your decision wasn't right. You should have done as we said, and in fact, not taken our chickens. That was an unconstitutional seizure of property. Well, in that case, and in many since then, the courts decided that no, we will defer to the agency, and in fact not ask the question of scientific merit of the case, but whether or not we believe that the agency had the right to make those public health emergency decisions. And in fact, the ruling said, and I'll quote for you here, it is not for the courts to determine which scientific view is correct in ruling upon whether the police power, we're talking here about the police power, has been properly exercised. The judicial function is exhausted with the discovery that the relation between the means and the ends is not wholly vain, fanciful, or an illusory pretense. So the courts can deem that the enabling legislation doesn't include the agency's activities. I'm sorry. The courts can decide what the scope of the power of the agency is, but it generally defers to the agency's decisions when it acts within its scope. So I hope that that's clear. The FDA is looked to by the courts and generally allowed to function however it wants in the promulgation of its mission. But its mission and how far that goes is determined by the courts. So, for example, there were cases some years back when American physicians wanted to concoct up some homemade remedies and administer them to patients. And the administration, the executive branch of government, came to the court and said, no, we have the power to regulate drugs. To which the courts said, no, this is the regulation of the practice of medicine, and the agency is not permitted to regulate the practice of medicine. So the courts can put a limitation upon the agency's scope of power. The courts can also review and overturn the agency's failure to act, not only its actions, but the things that it didn't do that it thinks it should have done. For example, the Secretary of Health and Human Services refused to promulgate a ruling that would ban the interstate shipment, remember we said that we regulate interstate commerce, interstate shipment of unpasteurized milk, in spite of the fact that there were abundant evidence that unpasteurized milk represented a real public health threat. So a citizens group sued the agency, and in the course of the court determined that the agency had failed and ordered the administration to, in fact, move forward and promulgate regulations banning the interstate shipment of unpasteurized milk. So there you have it in a nutshell. I did want to mention that administrative law is quite different from adversarial law, in that administrative hearings, the judge at HHS or in the Food and Drug Administration can act as a prosecutor and judge. So it's quite different from that adversarial system upon which most of our court is based. This instead is called an inquisitorial system. So it's different from adversary judges and administrative proceedings. The good news is, though, that administrative proceedings cost considerably less and there are no juries, and so they go quite a bit faster. So, in summary, American democracy is the context in which the regulation of foods and drugs, the most regulated products in America, are considered. The regulation of these products is essential to the health of the industry. I didn't go into all of the patent medicines that we had prior to, in the earlier centuries, prior to really standing up the Food, Drug, and Cosmetic Act and other safeguards that we have. But as much as industry is known to bellyache about what can be considered by some the poor state of regulatory affairs in America, our entire biotech industry depends upon a strong regulatory system. That regulatory system is set in the context of an American democracy, an American Constitution. Others have imitated and advanced, in some cases leapfrogged over the U.S. system, but it remains perhaps the gold standard in the United States is that the FDA and the EMA and the MHLW in Japan, the FDA having certain special innovations that I think any serious professional working in the pharmaceutical industry needs to learn how the FDA functions and operates and where it's coming from. So with that, this is my very first lecture in my very first course. I look forward to the discussions that we're going to have about this lecture and other lectures to come, as well as to hearing more of the students' presentations on the particular guidances we select for your presentations. And with that, lecture 1 is finished. Thank you. Bye-bye.